sir. That's fine.
But if the court were to body you would see that not only is he orientated towards Officer Brown, Officer Brown's in the present gone. So his full attention is in the direction of Officer Brown, and you'll see as he turns, reaches, puts the vehicle in gear, he's oriented forward. None of the evidence ever shows him looking in the direction or having any interaction with Officer Sullivan. Which is video evidence.
Yeah, so I understand what you're saying, and I guess my the consideration is that your interpretation of the video evidence is that because of his face facing Officer Brown, that he could not have been aware of Sergeant Sullivan.
Not only facing Judge, they're in the middle of him grabbing his cuffed arm. The two of them are having an interaction together, and that's where his focus is.
I think the body camera also shows that he has twisted away from Officer Brown to be able to enter the vehicle, and to grab the vehicle and to keep the car in here.
objection to criminal negligent homicide. So that's going to be removed from the charge. I believe that there's affirmative evidence showing that he was not aware of the circumstances. Papa? You're welcome to make a proffer for.
Oh,
the record.
I'm sorry, Judge, I actually brought a sample.
Up the proffer that you wanted to
Should
put
we
into
read
the
it into
record?
the record? Yes,
Sure.
Judge, that's fine.
You can read into the record, or you can
I'll just
do it as an exhibit.
Yeah,
However you want to do
yeah,
it.
I can do it.
All right, Ms. Mills. This is the bill of proof. I don't know how you handle the bill of proof, but that is,
It should be his
proper.
defense one. Mr. Rush, you need to stick it.
Yes, ma'am, thank you.
Yeah, you can put that as one proof, add it as your actual proof.
Yes, ma'am, thank you. And Judge, this time for the record, I will offer defense one for appellate purposes. Select proposed jury instruction on criminally negligent homicide.
Yes, sir.
See it, Amanda?
And, it's admitted for the purposes of appellate review, not be published.
Thank you.
Okay.
Judge, I'm sorry to interrupt. Before you print, we caught another typo that I made. In the actual verdict form for the lesser of assault public servant, it says assault peace servant instead.
Okay. one sentence in red, which, you know, it's printed in black and white, it does, the shade looks different. I am changing it to the whole thing to read black. And then I'll print out the final one, so that there's not any indication that one portion is less or more important.
Have a seat. If you cannot have a seat, if you cannot find a seat, wait outside. If you cannot find a seat, wait outside.
And Judge, I don't know if this is what you referenced, but the word "or" is underlined here.
Yes, I took that out. I went through and did a select all, and I removed any formattings, any underlines, any italicized, any bold. And then I turned all the font black. I'll let y'all inspect the one that I'm gonna read to the jury and turn over to the jury. I need to remove very form.
Y'all can't find out where the city's wait in the hallway.
Y'all have a chance to review?
clarify, Your Honor, criminally negligent homicide is still in the verdict form?
I took that out, yes, thank you, and I'm printing out another copy for your inspection.
On page 6, there's just formatting issues. Once we get to the 404B instruction, it kind of breaks things apart.
Yes.
I couldn't figure out how to fix it when I was editing it either.
And I also fix the formatting and spacing issues. I've removed the verdict I've removed from the verdict form the option for criminally negligent homicide. I have changed the font, the color of the font all to black. And I've removed any of the special effects on any of the font, including underline, bold, or italicized. Any other?
Not from the state, no.
Nothing else, Judge.
I'll be right back with the final version for your approval.
Mark on the order, remain seated. to see you.
Judge, no additional objections.
Your Honor, the state has no objection to the charge.
Thank you. Last we checked, we were waiting on one juror. I'm gonna have the bailiffs to go check. And then as soon as we have everybody, we'll get started. All right, the jury's here. We're gonna bring them out. Wait, Mr. Rushing. So you can go ahead and round them out. Dwayne Henderson stands charged by indictment with the offense of capital murder alleged to have been committed on or about the 10th of December 2019 in Harris County, Texas. The defendant is not guilty. A person commits the offense of capital murder if he intentionally or knowingly commits murder, as herein defined, and the person murders a peace officer who is acting in the lawful discharge of an official duty, and who the person knows is a peace officer. A person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Peace officer means a person elected, employed, or appointed as a peace officer, including a police officer of a municipality. Deadly weapon means a firearm or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial or unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise as viewed from the defendant's standpoint. Before you would be warranted in finding the defendant guilty of capital murder of a peace officer, you must find from the evidence all elements have been proved beyond a reasonable doubt. You are instructed that you may consider all relevant facts and circumstances surrounding the death and any previous relationship existing between the accused and Kaila Sullivan, if any, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense, if any. Now, if you find from the evidence beyond a reasonable doubt that in Harris County, Texas, on or about the 10th of December 2019, the defendant Tavores Henderson did then and there unlawfully, intentionally, or knowingly cause the death of Kaila Sullivan, a peace officer, in the lawful discharge of an official duty by striking, running over, or dragging Kaila Sullivan with his motor vehicle, knowing at the time that Kaila Sullivan was a peace officer, then you will find the defendant guilty of capital murder as charged in the indictment. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt as to any of the foregoing elements of capital murder, or if you are unable to agree, you will next consider whether the defendant is guilty of the lesser offense of aggravated assault of a public servant. A person commits the offense of aggravated assault of a public servant if he commits assault as defined, and the person causes serious bodily injury to another or uses or exhibits a deadly weapon during the commission of the assault, and when the defendant knows the person assaulted is a public servant while the public servant is lawfully discharging an official duty. A person commits the offense of assault if the person intentionally or knowingly or recklessly causes bodily injury to another. Public servant means officer, employee, or agent of government. Government means the state, a county, municipality, or political subdivision of the state, or any branch or agency of the state, a county, municipality, or political subdivision. The defendant is presumed to have known the person assaulted was a public servant if the person was wearing a distinctive uniform or badge indicating the person's employment as a public servant. You are further instructed that the facts giving rise to the presumption must be proven beyond a reasonable doubt, and that if such facts are proven beyond a reasonable doubt, you may find the element of the offense sought to be presumed exists, but you are not bound to so find. and that even though you may find the existence of such element, the state must prove beyond a reasonable doubt each of the other elements of the offense charged. And if you have a reasonable doubt as to the existence of a fact or facts giving rise to the presumption fails, and you shall not consider the presumption for any purpose. Therefore, if you find from the evidence beyond a reasonable doubt that in Harris County, Texas, on or about the 10th of December 2019, the defendant, Tavores Henderson, did then and there unlawfully, intentionally, or knowingly, or recklessly cause serious bodily injury to Kaila Sullivan while Kaila Sullivan was lawfully discharging an official duty, knowing that Kaila Sullivan was a public servant, or did then and there unlawfully, intentionally, or knowingly, or recklessly cause bodily injury to Kaila Sullivan while Kaila Sullivan was lawfully discharging an official duty by using or exhibiting a deadly weapon, namely a motor vehicle, knowing that Kaila Sullivan was a public servant, then you will find the defendant guilty of aggravated assault on a public servant. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of aggravated assault on a public servant. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either capital murder or aggravated assault on a public servant, but you have a reasonable doubt as to which of the said offenses he is guilty, then you must resolve that doubt in the defendant's favor and find him guilty of the lesser offense of aggravated assault on a public servant. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of the lesser offense of manslaughter. Our law provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. Therefore, if you find from the evidence beyond a reasonable doubt that in Harris County, Texas, on or about the 10th of December 2019, the defendant, Tavores Henderson, did then and there unlawfully, recklessly, as that term is hereinbefore defined, caused the death of Kaila Sullivan by striking or running over or dragging Kaila Sullivan with the motor vehicle, then you will find the defendant guilty of manslaughter. If you find from the evidence beyond a reasonable doubt that the defendant is guilty of either aggravated assault on a public servant on the one hand, or manslaughter on the other hand, but you have a reasonable doubt as to which of said offenses he is guilty, then you must resolve that doubt in the defendant's favor and find him guilty of the lesser offense of manslaughter. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict not guilty. You are further instructed that if there is any evidence before you in this case regarding the defendant's committing an alleged offense or offenses other than the offense alleged against him in the indictment in this case, you cannot consider such evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense or offenses, if any, and even then you may only consider the same in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident of the defendant, if any, in connection with the offense, if any, alleged against him in the indictment and for no other purpose. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that he has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given their testimony, but the law you shall receive in these written instructions, and you must be governed thereby. After you retire to the jury room, you should select one of your members as foreperson. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as foreperson. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. No one has any authority to communicate with you except the officer who has you in charge. After you have retired, you may communicate with this court in writing through this officer. Any communication relative to the cause must be written, prepared, and signed by the foreperson, and shall be submitted to the court through this officer. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause, and restrict your deliberations solely to the issue of guilt or innocence of the defendant. Your verdict must be by a unanimous vote of all members of the jury. Following the arguments of counsel, you will retire to consider your verdict. Signed, Melissa M. Morris, Judge of the 263rd District Court, Harris County, Texas.
On December 10th of 2019, Sergeant Kaila Sullivan put on her uniform for the very last time. And she went out to patrol and protect and serve our community. And as she zipped up her boots, Sergeant Sullivan had no idea that her left boot would be drug off of her foot and left behind at the scene of her murder. And as she strapped on her bulletproof vest, Sergeant Sullivan couldn't have possibly known that hours later, her rookie officer, Officer Clinton Brown, 26 years old and just 10 months on the force, would be the one to rip it off of her limp body as he desperately tried to save her life. And when Sergeant Sullivan put on her gloves, it was cold that day, and she put on that beanie, she didn't know that it was going to be one of the last things that her killer, Tavores Henderson, saw as he took deliberate and conscious actions to get her out of his vehicle, to flee that scene, to escape by any means necessary, even if it meant killing her. On December 10th, 2019, as Tavores Henderson is stepping on that accelerator. He is flooring the gas, trying to get her out because she is an obstacle. Sergeant Sullivan knows. And Sergeant Sullivan is holding on for her life. She is fighting for her life. As he is fighting off Officer Brown, he is stepping on that gas. And stepping on that gas is no different than if he would have taken that gun and pulled that trigger. He is taking deliberate action. That's intent. And as he continues to drive, speeding through that parking lot, Sergeant Sullivan knows that it is reasonably certain that she's about to die. And as he hits that bump and he feels it, because you can see it in the video, that bump that was her body, Sergeant Sullivan knows that she is going to.
Objection, arguing facts not in evidence.
You can reasonably deduce from the evidence that at that moment, Sergeant Sullivan knows she is going to die. And so did Tavores Henderson. He knew exactly what he was doing, and he knew she was a police officer on duty when he took several conscious and deliberate steps to get away by any means necessary, including taking her life. A life that Kaila Sullivan put on the line every single day to protect you, me, and our community. And because he acted intentionally, and because he acted knowingly, taking her life is capital murder. On December 10th, 2019, when Sergeant Sullivan put on her uniform for the last time and left her home for the last time, she had no idea that almost 6 years later, all of us would come together to talk about her murder at the hands of this man. And exactly a week ago today, we all met on the 20th floor of this building. And a week ago, we couldn't talk about the facts of the case, but we talked to you about the law. And we talked to you so much about intentionally and knowingly that it wasn't a surprise to you when the trial started and the first thing you heard from his attorney was, "I didn't mean to do it. He didn't mean to do it. He panicked." But each and every one of you is here on this jury today because you all understood that when it comes to the law and when it comes to a case like this, we don't follow the everyday meaning that we give to words like intentionally or knowingly or recklessly. You have to apply the facts to their legal definitions. And you weren't surprised at all when the first thing that you heard was, "I didn't intend to. I didn't know. I did something, but it's not that serious." We talked about this in jury selection, remember? He panicked. That's not a defense to capital murder. And remember what I asked you to promise me. You promised me that if you heard a defense in this case, you would ask yourself, is it reasonable? So is it? Knowing what you know now, knowing that intent or knowledge is something that can be formed in an instant, knowing that you can infer somebody's intent or knowledge from the totality of the circumstances, from the context, from what he was doing before, from what he did immediately after. Is it reasonable? Or is that just what somebody has to say whenever they're caught on video murdering a police officer? you may have questions still in this case.